Hi, class. Today we're going to be looking at Chapter 1 in Payroll Accounting. I'd like to welcome you to my class, and I'm going to show you some notes that I've prepared for this class. You should be able to see some notes that I prepared for Chapter 1. In Chapter 1, we don't have any mathematical problems that we're going to be doing. So what I want to do with you is I want to go over some of the terminology in Chapter 1. Your first assignment is just going to be multiple choice questions. And so you need to make sure that you have read the first chapter. And what we're going to talk about today is just some basic terms in payroll accounting and some things that you need to become familiar with. And there will be also some things that we're going to introduce to you today, but you will be doing those later on in your chapters that are coming. This first chapter is just an introduction to some of the things that you're going to be needing to collect for your company. And we're going to show you some things about the laws that are in effect that cause us to have to keep certain documents. I'm not going to read all of the notes to you. I know that you can do this, but I am going to post these notes to Blackboard so that you can read them for yourselves and study over them. But there are some things that are very important that I would like to point out about some of the items that you can find in these notes. First of all, this chapter really talks a lot about some of the payroll laws that we're going to be studying in detail in the coming chapters. It's important that you know some information about some of the federal laws as well as state laws that we're going to be talking about that are important for you to know before you keep your record keeping in payroll accounting. One of the first laws that they introduced to you that is a federal law is what we call the Fair Labor Standards Act. The Fair Labor Standards Act, or it's sometimes called the Federal Wage and Hour Law, is laws where they're going to tell you they're laws that our government has made to set the minimum wage and overtime pay requirements for your employees. Right now, all you need to know in this chapter is that the Fair Labor Standards Act, or the Federal Wage and Hour Law, sets minimum wage and overtime pay requirements. The current minimum wage is $7.25. Some other laws that our government has enacted is the Federal Insurance Contributions Act, or FICA for short. And what FICA is, it's a tax that is levied on employees. So if you've ever gotten a paycheck, you can be assured that you've got some FICA taxes taken out. These FICA taxes are for Social Security and Medicare. That's what we call them. There's a Social Security and Medicare tax was discussed and brought up in the Federal Insurance Contributions Act that the government made up. This tax is levied on employees. So again, you may have seen it coming out of your paycheck, but I don't know that you know that your employer also has to match this particular tax. So both the employer and the employee pay FICA taxes, or they contribute to your Social Security and your Medicare tax. Even if you're self-employed and you own your own business, you have to pay FICA taxes. And if you're self-employed, you have to pay a portion as the employee and also as the employer. So your self-employment taxes can become rather high, but these are taxes that are taken out for Social Security and Medicare. It is made up of what the government calls the Old Age Survivors Trust Fund and the Federal Disability Insurance Trust Fund. But basically, the tax is called FICA. A portion of it goes toward Medicare, and a portion of it goes to health insurance and contributions. And I will talk to you a lot more about this in an upcoming chapter. Again, in today's lesson, we just want to talk briefly about the different types of laws that are out there. And then in upcoming chapters, we're going to discuss them a whole lot. The next one that I feel like I need to mention is income tax withholding laws. Now, this is both a federal income tax withholding law, and also there's a state income tax withholding law. So again, if you've ever been paid a pay and you've looked at your paycheck stub, you'll be seeing that they take federal taxes out on you as well as state taxes. These are the income taxes that are withheld from your paycheck, and they are used to pay for general government programs. Another type of tax that you need to become familiar with when you're working in payroll is the Unemployment Tax Act. And there is both a state tax and a federal unemployment tax that we need to talk about. The state and the federal unemployment tax is levied on employers. All employers pay state and federal unemployment taxes. However, in some states, employees also have to contribute to unemployment taxes depending on their state's employer's unemployment record. In North Carolina, we don't have one of these taxes yet. And that's because our unemployment is not that high. But in states such as California, employees have to pay this tax as well as the employer does. But for our purposes, the general purposes that we're going to use this for in this textbook, this is a tax that would be levied on the employers. Now, the federal unemployment tax, which we refer to as FUTA, is used to pay the administrative expenses for the unemployment program. Your state unemployment taxes are what are used to pay unemployment benefits to unemployed persons. So again, the employer has to be familiar with state and federal unemployment taxes because they're going to have to contribute to those taxes. And again, later on, we'll talk a lot more about unemployment tax in a different chapter. What we also have to look forward to is what we call fair employment laws. You need to become familiar with these in payroll because these laws deal with discrimination practices. The fair employment laws want to make sure that no employer is discriminating against its employees based on race, age, color, religion, gender, or national origin. Most of you probably are familiar with the Civil Rights Act of 1964. This is also sometimes referred to as Title VII. It's entitled the Equal Employment Opportunity Act, and it forbids employers to discriminate in hiring, firing, and promoting or compensating on the basis of race, color, religion, gender, or national origin. The Equal Employment Opportunity Commission provides guidelines that include the physical definition of national origin discrimination, because unnecessary height and weight requirements for some jobs could exclude some individuals from being fired from a job. Also, that something that falls underneath this act is the EEOC, or the Equal Employment Opportunity Commission, has declared sexual harassment as a violation of the Civil Rights Act. So basically, the Civil Rights Act, as you all are probably already familiar with, forbids employers to discriminate in hiring and firing and promoting or compensating on the basis of race, color, religion, gender, or national origin. Also, under fair employment laws, we have laws for age discrimination in employment. This act, referred to as ADEA, prohibits employers from discrimination on the basis of age. It provides protection for employees over age 40, with the exception of employers who are age 65 or older, who have held high policy-making positions during a 2-year period prior to retirement. If an employee is entitled to an annual retirement benefit of at least $44,000, employees can be forcibly retired. But the Age Discrimination in Employment Act is designed to protect employees by prohibiting employers from discrimination on the basis of age. It provides protection for employees that are over the age of 40. Another fair employment law that you need to become familiar with is the Americans with Disabilities Act, or ADA. And this act is going to prohibit employers from discriminating against persons with disabilities because they have a disability. Companies must provide reasonable accommodations for applicants and workers. So if an employer cannot discriminate against a person with a disability, and by reasonable accommodations, a lot of times they mean that you need to have access to the building where you have wheelchair access. And as long as the employee can do the job, you should not discriminate against them because they have a disability. There are also other laws that they touch on in this chapter that have a need for keeping payroll and personnel records. One of those laws is what we call the Federal Personal Responsibility and Work Opportunity Reconciliation Act. This act basically is to ensure that all employers report new hires to the government, because they want to make sure that persons who need to be paying child support will be paying child support. And so this act requires all states to report new hires. And each employer has to send in the new hire's name, address, social security number, and they, as the employer, also have to report their company's name and address and federal ID number to the state directory of new hire reporting. They have to do this within 20 days of the hire of a new employee. This information is then forwarded within 5 business days to the Federal Office of Child Support Enforcement, where it's entered in a national directory of new hires. And if companies fail to report new hires, they can be fined for this. But the Federal Personal Responsibility and Work Opportunity Reconciliation Act is basically to aid in the enforcement of people paying child support. Another federal law that you need to know about is the Immigration Reform and Control Act. And this act bars employers from hiring unauthorized persons to work in the United States. Employers are required to examine the employee's verification documents for eligibility and to have employees complete Section 1 of what we call Form I-9. This is the Employment Eligibility Verification Form. So when you have someone that you are getting ready to hire and everybody has to prove that they are eligible to work in the United States. So you have to have some kind of verification for eligibility. So employers have to make sure that the employee completes the Part 1 section for verification of eligibility to work in the United States. The I-9 has a second section that has to be completed by the employer, and they have to do this within 3 business days of the employee's first day of work. The person also that signs Section 2 as the employer must be the same person that examines the verification documents that the persons have the right to work in the United States. Form I-9 is a document that all payroll or personnel have to keep a record of, but it should be kept separate from other personnel records for privacy. Form I-9 should be retained by the employer for 3 years, and if employees do not adhere to the Immigration Reform and Control Act, employers can be fined for that. So these are laws that you need to become familiar with if you're working in payroll and personnel records. And by the way, payroll in some companies is kept separate from the personnel records. But in today's world, the trend is for personnel to take care of payroll records. So some things have changed over the years, and it's not just a payroll department that we're talking about. The payroll can come underneath the personnel department. In the old days, when I first started working, which was a long time ago, we used to have separate payroll departments, and we reported to our finance officers. I actually used to work in payroll for a little while at one of the companies that I worked with. Also, as a part of immigration reform and control, there is an internet-based system called E-Verify that will allow employers to check the employment eligibility of new hires. What they're going to do is they're going to compare the information that they've collected on the I-9 form with the Social Security Administration and Department of Homeland Security. E-Verify basically verifies that there's a Social Security number for the employee. And if the employee does not have a Social Security number, they need to go ahead and apply for that as soon as possible. Family Medical Leave Act is another federal act that was enacted that actually allows workers some unpaid leave for family or medical emergencies. In the cases of childbirth, adoptions of children, serious illness of the employee or the employee's child or spouse, or maybe you have a parent that's ill, the employer can offer as many as 12 weeks of unpaid leave. The leave has to be taken within 1 year of the event, and it is the employer's obligation to designate the leave. In other words, the employee can't pick and choose when they want to use the Family Medical Leave Act time. But this was an act that's set aside to help people who have family or medical emergencies. If an employee goes on FMLA time, then the employer must continue their health care coverage. And they also guarantee that the employee will have the same job or a comparable one when they return from the leave. So the Family Medical Leave Act was designed to allow workers to get unpaid leave for family or medical emergencies. Now, in some companies, they will actually pay for the leave, but that's up to the particular companies. But all companies have to adhere to the Family Medical Leave Act. And so if you need leave for a family or medical emergency, you can request that of your employer, and they can offer you as many as 12 weeks of unpaid leave. Another thing that you may or may not be familiar with is that there is a Uniform Services Employment and Reemployment Rights Act. And what this does is it gives military personnel the right to take leave of absences from their civilian jobs for active military service so that they may return to their jobs with accrued seniority. So if you're employing a employee who is on active duty, maybe in the National Guard, they might be in the active duty for the Army, then if they are called to active service, then there are laws that are designed to protect these military personnel. They have the right to take leave of absences from their jobs for active military service so that they, when they return to their jobs, they still have accrued seniority. There's also an act called Employee Retirement Income Security Act, and this ensures workers that are covered by private employee pension plans that they receive benefits from those plans. The term vesting is an important term when we talk about retirement, because vesting conveys to employees the right to share in a retirement fund if they are terminated before the normal retirement age. So full vesting can occur in 3 years or gradually over 6 years. If you've worked with the company for 6 years and they have a pension plan that you have been contributing to and that your employer has been contributed to, you are guaranteed benefits from those plans. Even though you might quit after 10 years, you are vested with those retirement plans. So that's important for everyone, I think, to know about. Also, you probably have heard of this one, the Affordable Care Act. This was a part of Obamacare, and this act was designed to expand health insurance coverage for more Americans while increasing health care benefits and lowering the cost for consumers. And so the Affordable Care Act has established what we call state-based health exchanges for those people who do not have access to employer-provided coverage or who do not qualify for programs like Medicaid. Under the Affordable Care Act, if you're a large employer with 50 or more full-time employees, you are required to provide insurance coverage for all full-time employees and their dependents. So if you're a large employer with 50 or more full-time employees, you have to provide insurance coverage for your employees. If you're a smaller employer, you have less than 50 employees, you can take advantage of an income tax credit that is established just for you as small employers who will offer health care benefits to their employees. This is to encourage all employers to offer some type of health care benefits to their employees. So the small companies will get a tax credit for offering benefits to their employees, but the larger companies are required by the government to offer full-time coverage for the employees. So under Affordable Care Act, the government wanted to make sure that everyone had some type of health insurance. And so that's why that act was established. There are also some state laws that affect the needs for payroll and personnel records. One of those is what we call workers' compensation laws. So if you are adhering to worker compensation laws, as an employer, you're required to carry workers' compensation insurance, which would be used to protect employees and their dependents from loss due to work-related injury, illness, or death. So workers' compensation has to do with work-related injury or death. Insurance benefits would be paid to the employees that cover the medical bills and also provide a percentage of the worker's wages during the time the employee is unable to work. There are also what we call state disability benefit laws. And not all states have these, but some have passed laws to provide disability benefits to employees absent from their jobs because of illness, accident, disease not arising out of their employment. So we'll be talking more about that in an upcoming chapter. The second part of this chapter is devoted to human resources and payroll records that you would need to have available and on hand for your business. First of all, they talk about a job description. So if you need an employee and you're advertising for an employee, there should be some type of job description that the company has prepared before the job is advertised. And it includes information such as the title or the position that they're needing, what the job duties are going to be, what type of skills that you need to have necessary, if there's any work experience that is needed, any education requirements that's needed. And usually a job description tells who would be your department or supervisor and describes a little bit about the working conditions of the job. So it's very important to have a job description for every job that a company has or offers to uh, their employees. So if they need another employee, they'll know what the job description is. Also, companies need to have in place probably a form for the requisition for personnel. And this requisition for personnel is just a form basically that notifies human resources that a department or someone within the company needs additional employees or replacement employees. Usually that form will have information on it about the number of persons that are needed, the type of position to be filled, and what the salary or rate of pay will be, and whether it's going to be a full-time or part-time position. So before a person is hired, someone should fill out a request for personnel, especially if it's in larger companies. Also, an application for employment is needed for every business, whether it's large or small. They should have some type of application form that would be filled out by a person seeking employment. And anyone who has tried to get a job most likely has filled out an application. And you probably know that on an application, they ask you for personal information, educational background, employment experience, and the type of position that is desired that you are wanting to apply for. Some of them have places where you can record references on the applications. And usually there's some type of statement on the application that affirms that the employers has a right to verify information on the application. Applications are records that have to be kept by the business. They have to be kept on file for 1 year. And while we're talking about an application for employment, applications really have pre-hire inquiries on them, which are questions that are asked on the resume, or excuse me, that are asked on the application, or they might actually be asked in the employee interview if the applicant has made it to that point in time. Now, pre-hire inquiries are subject to the fair employment laws that we talked about earlier. Questions on the application and in the interview should be only used to determine the applicant's ability to do the job. And so you can ask questions of your employees, but you have to be careful not to ask questions that would be considered to be discrimination against the applicant. I think it's important that we should note that none of the federal civil laws outlaw interview questions about race, color, religion, gender, or national origin. However, the questions must be related to the bona fide occupational qualifications for the job. So if you have questions about, someone's race, their religion, or their national origin, those questions have to be specific toward qualifications for the job. Otherwise, you could get into some trouble for illegal hiring practices. I thought it was also interesting in your textbook that they pointed out that you can ask questions about arrest records during the employee interview, but you can't ask for a copy of the records. That is illegal. You can do background checks only if there's a solid reason for the background check. And the background check has to comply with what they call the Fair Credit Reporting Act. If a background check is completed, the applicant must be notified in writing, and the applicant must sign the notification, and the applicant must be given a copy of the report once it's filed with the Fair Credit Reporting Agency. And that's so that employers will not make adverse employment decisions. Also, if the company is doing a background check, the company has to provide a copy of the government document called a summary of your rights under the FCRA to employees who are subject to background checks. That's the Fair Credit Reporting Act. Causes them to do that. All aptitude and psychological testing are unlawful unless the results can be related to job performance. Personality tests have to be approved by the Equal Opportunity Commission. Excuse me. Lie detector tests are illegal, and drug testing must comply with state laws. So you need to become familiar with your state laws if you're doing drug testing for your company. Questions about age on the application should only be asked to determine the applicant's ability to perform the job. A statement from the EA should be placed on the application that states that ADEA prohibits discrimination on the basis of on the basis of age. To prevent lawsuits, companies should, this is something that companies can do to help them to prevent lawsuits, accept applications online, and they need to have someone that is not involved in the interview process review the applications. Screen applications with computer software that look for experience, education, and training characteristics. These are some things that companies can do to help them prevent lawsuits. With reference inquiry, companies should be careful when checking on references supplied by an applicant because of increasing lawsuits. Most cases, respondents will verify dates of employment and job titles only. Most people that you ask, if you're calling from personnel to an employee that you might be interested in, they won't give you, a former employer won't give you the work habits of the employee. They'll just verify that, yeah, you worked there and what the job title was. And that's to keep them from being, having lawsuits brought against them too. A hiring notice is a form that is sent to the payroll department so that the employee can be added to the payroll. The employee history record is a record of the relationship between the employee and the employer. It contains information about the employee's progress, their attendance, promotions, performance appraisals, and salary increases. These are records that we would have to maintain in the personnel department or the payroll department, and employee history record. A change in payroll rate would notify the proper department of changes in pay. So these are some forms that you should become familiar with if you're working in payroll. A company's record-keeping system should consist of a personnel file, a payroll file, a medical file, and a separate form for those I-9 forms that we talked about earlier. And a payroll accounting system is basically a procedure or method that's used to disperse pay to employees. In this textbook, we're going to talk mainly about manual payroll systems. We're going to learn how to use what is called a payroll register, which they introduce at the end of this chapter. And they also talk to you about an employee earnings record, but we're going to see a lot of this payroll register. And the payroll register is basically a multi-column form that is used to assemble and summarize data needed at the end of each payroll period. And what it'll do is it'll consist of a list of employees, the amount of total earnings, and the deductions that are taken out on the employee, as well as the net amount that is paid to the employee. And this payroll register is used to file reports to the government and also to record payroll entries. There's an actual example in your text at the bottom, page 1-24, and I feel like you need to at least look at that and get familiar with this form, because we're going to be doing a whole lot more with it as the class progresses. An employee's earnings record also provides information about the accumulated earnings of each employee. So every employee has their own employee's earnings record. And this information would be taken from the payroll register and placed into the employee's earnings record. And this employee's earnings record is what companies use to prepare your W-2 forms, which you all probably are real familiar with about this time of year, because on January 31st, all your employers have to furnish you with a W-2 form. There's an example of an employee's earnings record also on page chapter 1, page 25. Now, a lot of companies are starting to outsource payroll. This is a trend in payroll accounting. So many small to mid-sized companies find that it's cost effective to send their payroll to an outside payroll company that does nothing but payroll. They want to outsource their payroll. New employee information and the number of hours worked by each employee can be sent to the outsourcing company, where the information would be processed and returned to the company in form of paychecks, payroll, and management reports. So I'm going to post these notes in your course. I'd like for you to study over them. And I'd also like you to read your chapter. Make sure you read your chapter. And then you're going to do the questions at the end of the chapter, which are in Cengage. And these will be multiple choice questions. You're also going to have a test, and your first test is going to consist of multiple choice questions on this information. So stay tuned, because later on I'm going to be making some more videos with you for your next chapter. This is the only video that I'm going to make for you in this chapter, but I'll be making more for the remaining chapters. So I hope you've enjoyed this session, and we will see you soon. Bye-bye.